Have got. All right, and having received the go-ahead, let's call the case of Marks versus Sonny's Rooftop Barbecue. And I am Judge Michael Iyer. Scoring judges, would you please look to the two buttons on the lower left of your screen and turn off your audio and video. These should remain off until the trial ends. You should also have your video set to hide all non-video participants. This means the only people on the screen right now should be the advocates and me. And then at this point, then, if we could start with appearances and starting with the plaintiff.
Yes, Your Honor. Good afternoon. My name is Connor Wright on behalf of the plaintiff. I'm joined today by my second chair, Ethan Wright.
Good afternoon, Your Honor.
All right, good afternoon. And for the defense?
Yes, Your Honor. Good afternoon, Your Honor. My name is Madeline Levin, and today I represent Sonny's Rooftop Bar. I'm joined by my co-counsel, Ms. Becker. Good afternoon, Your Honor. While you won't be able to see or hear Ms. Becker, she'll be assisting me with the technological components of today's trial.
All right, thank you very much. And before we call any witnesses or have opening statements, do we have any preliminary matters to address?
Yes, Your Honor.
All right.
First, Your Honor, we'd like to invoke Rule 603, swearing in all witnesses in trial today.
All right, all witnesses are constructively sworn at this time. I'm not going to be individually having them sworn during the trial then.
Second, we'd like to invoke Rule 615, constructively sequestering all witnesses save the defendant.
Right, party witnesses have a right to be present, and so with the exception of party representatives, then all other witnesses are constructively sequestered at this time.
And finally, Your Honor, pursuant to Rule 9D, all witnesses in this case have a virtual notebook of all exhibits.
All right. Thank you for bringing that to my attention. Anything else, Mr. Wright?
No, Your Honor. With that, the plaintiff is ready to proceed to opening statements.
All right. And Ms. Levin, are there any preliminary matters you wish to address?
Yes, Your Honor. As it relates to screen sharing, may we assume that when authenticating an exhibit, it's constructively outside the presence of the jury, and that once entered, it's published?
Well, yes. Obviously for purposes of educating everybody, it's more beneficial if you do put the exhibits up, but they're not in evidence until they're moved into consider any objections, and then when they are received into evidence.
Of course, Your Honor. And if you can't see or hear me at any point, please do let me know either in the chat or verbally, and I'll do what I can to fix it.
I certainly will. All right.
And with that, defense is ready to proceed with opening statements.
All right. Then at this point then, Mr. Wright, we'll start with your opening statement. But before we do that, if everyone would make sure that they are in speaker view, that way the button is on the upper right of your screen, and attorneys, please remember to mute your audio when the other attorney is speaking. And then with that, Mr. Wright, when you're ready to begin the plaintiff's opening statement, you may proceed.
Of course, Your Honor. They saw, they served, they didn't stop. March 24th, 2019. A woman named Jessica Marks is sitting at a table at a rooftop bar. In front of her, 2 hard seltzers, a crushed can of beer, half a bottle of wine. She's slurring her words. Her vision is blurry. She can hardly even walk straight. She has her best friend try and help her downstairs. And she falls straight into the defendant at the base of the steps. The defendant calls out to her bar employees, "We need to cut this one off." Members of the jury, today you're going to learn that 40 minutes And 2 shots later, the defendant watches. Jessica Marks leaves that bar. 30 seconds after getting onto the road that night, Jessica Marks crashes. She's dead at the bottom of a ravine, a BAC 0.16. She was only 19 years old. They saw, they served, and they didn't stop. That's why we're here today. That bar has a name. Sonny's Rooftop Bar, the defendant. The Jessica Marks' death, it could have been avoided. The law requires bars like the defendant that serve alcohol to obviously intoxicated minors to be held accountable when any damages come to result. And today we'll prove, by a preponderance of the evidence, more likely than not, the defendant served alcohol to an obviously intoxicated minor. And those drinks caused her death. And we'll do that by showing you how they saw, they served, and they never stopped. You'll hear from Jessica's best friend, Morgan Levin. She'll tell you how the 2 of them were minors, how they got into that bar, and how Jessica became more and more intoxicated throughout the night. I'll show you pictures of their table. You'll see wine, beer, seltzer, shots. Jessica became more and more intoxicated. Her behavior became more and more obvious. We'll provide eyewitness testimony that other people in the bar that night saw how Jessica was acting, watched the defendant serve her more drinks, and watched. The defendant didn't stop her from leaving. At the end of today's trial, we'll ask you to find Sonny's Rooftop Bar liable because they saw, they served, and they didn't stop. Thank you.
All right, thank you, Mr. Wright. And at this point, Ms. Levin, are you prepared to give the defense opening statement?
Yes, Your Honor.
Anytime you're ready, you may proceed.
She controlled her choices. It's March 24th, 2019. Jessica Marks is standing at her car door. Keys in hand, she pauses. She's been drinking. She tells herself she'll be fine. She gets behind the wheel, and Miss Marks makes it to where she's going. Sonny's Rooftop Bar in Malibu. Members of the jury, you'll learn that moment in Miss Marks' car, it happened hours before Miss Marks ever set foot in Sonny's bar. And you'll learn that when she did, Miss Marks made a similar set of choices. At the end of a night of drinking around midnight, Miss Marks is again at her car door, keys in hand, and again she pauses. Reassures a friend she's gotten pretty good at driving after a big night. But this time, Miss Marks doesn't make it to where she's going. She's in a car crash, and she dies. Members of the jury, before I say anything else, let me say this. Jessica Marks' death is a horrible tragedy. A young woman lost her life too soon. Nothing that happens today is going to change that. But you've been tasked with determining who is responsible or liable for Miss Marks's death, and as devastating as it is, we'll prove Miss Marks controlled her choices, and those choices caused her death. Good afternoon. My name is Madeline Levin, and today I represent Sonny's Rooftop Bar. We are here because the plaintiff has brought a wrongful death suit. They've taken on a burden to prove that Miss Marks was served alcohol while obviously intoxicated. They'll fail to meet that burden. Because you'll hear today from the owner of the bar herself, Miss Sunny Mehta. She'll tell you she served Miss Marks a reasonable amount of alcohol, 5 drinks over the course of 3 hours, and that Miss Marks never exhibited any signs of intoxication. But we've also raised what's called an affirmative defense. We've taken on a burden to prove that Jessica Marks contributed, at least in part, to her own death. That's why you'll be asked to focus on Miss Marks's choices, the choices she made before she got to the bar, the choices she made after. You'll learn Miss Marks chose to drink, chose to drive. She controlled her choices. That's why, at the end of today's trial, we'll ask you to find Sonny's Rooftop Bar not liable. Thank you.
All right, thank you, Ms. Levin. At this point, before we call any witnesses, I'd ask that everybody switch to gallery view. That is the button in the upper right of your screen, and this will allow you to see the attorneys and witnesses at the same time. And then with that, Mr. Wright, are you prepared to call plaintiff's first and only witness?
Yes, Your Honor. At this time, the plaintiff calls Morgan Levin.
All right. And anytime you're ready, you may proceed with your direct.
Yes, Your Honor. Good afternoon, Ms. Levin.
Good afternoon.
Did you know Jessica Marks?
Yeah, I did. She was my best friend since junior high.
Ms. Levin, were you with Jessica on March 24th, 2019?
I was. Jess came over to California so we could finally spend some time together during spring break.
Did you go anywhere on March 24th?
We did. We went to this new bar called Sonny's Rooftop Bar.
What did you do when you got to the bar?
Well, Sonny's has this cool rooftop that we loved the view, wanted to take some pictures, so we went up the stairs to the rooftop.
Oh, did you and Jessica order any drinks that night?
Yeah, we did. We started off our order with a bottle of wine.
No. Did you order from the bar downstairs?
No, we had no reason to. The owner, Sunny Mehta, came to us the entire night, served us the entire time.
Did you take any pictures of your table upstairs that night?
Yeah, I did. We took a bunch of pictures.
On your virtual exhibit book, do you have exhibits 12, 13, and 15 in front of you?
I do. I have them.
What are they?
They are pictures that I took that night of our table of the drinks we had.
They appear fair and accurate?
Yeah, they do.
Your Honor, we move them into evidence.
Any objections?
No objections to those exhibits, Your Honor, pursuant to pretrial order 16.
All right, then they will be admitted at this time.
Mr. Wright, can we get those on the screen? Your Honor, these timestamps are stipulated. Now, Ms. Levin, I want to talk about these drinks. But first, let's talk about your interactions with the defendant. How many times would you say you interacted with the defendant?
think it was like 8 to 10 times that night.
And by the end of the night, did you get a receipt from the bar?
Yeah, we did. As I was going out to pay the tab, we got our receipt printed out.
You have Exhibit 17 in your booklet.
Yes, I do.
Do you recognize Exhibit 17?
I do. This is the receipt that was given to me from Sunny's rooftop bar.
Does it appear fair and accurate?
Yes, has my signature and everything.
You want to remove it into evidence?
Ms. Levin, any objection?
No objections to Exhibit 17, Your Honor.
All right, then 17 will be received into evidence as well.
Yes, Your Honor. Mr. Wright, can we get Exhibit 17 on screen? Ms. Levin, there were a lot of drinks on this receipt. How many of these drinks did you drink?
I only really had 2 and the glass of wine. So a beer, a shot, and a glass of wine.
From your perspective, how many did Jessica have?
The rest of the drinks, I didn't drink them.
I want to talk about those green tea shots in particular. Was that your last round of drinks?
Yes, it was. That was the last round Sunny brought to us.
Let's talk about the interactions you had with the defendant before she brought you this round of drinks. Can you tell us any of your interactions with the defendant?
Yeah, as Jessica and we wanted to go down the stairs to use the bathroom. And as we did so, Jess fell down the stairs right into Sunny.
Did the defendant say anything?
Yeah, she said, she turned to the other bartender and said, "Frankfurt, we should cut this one off." And pointed at Jessica.
Did the defendant cut Jessica off?
No, she didn't.
Objection, Your Honor. Speculation as to whether Miss Mehta actually cut Miss Marks off that night.
May I respond, Your Honor?
Yes?
This witness is testifying based on what she perceived that night, and under 701, she's giving her opinion as to whether or not she saw the defendant cut Jessica off.
May I respond to that, Your Honor?
Yes.
Your Honor, opposing counsel's question was, did Miss Mehta cut Miss Marks off that night? That requires this witness to testify to information that she would not know personally. We'd ask that opposing counsel rephrase his question.
May I respond?
Yes, I'll allow you one further opportunity to argue, and then I'm going to allow Ms. Levin to argue, and then I'll make a ruling at that time.
Yes, Your Honor. 2 things. First of all, Ms. Levin has testified that she was at the table and that she saw, she was with Jessica that entire night. So first of all, she can testify based on what she saw. Second, if it becomes too much of an issue, Ms. Levin can have a limiting instruction on her testimony that that's what she saw that night.
May I respond to that, Your Honor?
Yes, and then I'm going to rule.
Your Honor, this witness did testify that she was with Miss Marks at the bar that evening. She did not testify that she was with Miss Marks at every single point throughout the entire evening when Miss Mehta might have been interacting with Miss Marks. Therefore, opposing counsel's question is speculative. We'd ask that he rephrase.
All right, and I think that the question was whether she had been cut off or not. So I don't think that, that the other witness would have to be there the entire time. If she was there at part of the time, and during that part of the time the decedent had been cut off, then that would be within her own knowledge. But at this point, I don't think I've heard the words stating that some person operating the bar or the establishment had used those words. So at this point in time, I'm going to sustain the objection, subject to further foundation.
And motion to strike that testimony from the record?
At this time, yes.
Ms. Levin, did you hear the defendant say that we need to cut this one off?
I did. He said that right as Jessica fell down the stairs into her.
And did you ever see the defendant cut Jessica off?
No, I mean, Jess and we spent the entire night together, and each time Sunny served us.
So what time did the defendant say that Jessica needed to be cut off?
It was around 10 o'clock.
At any other time, did Jessica Marks do anything to make you think she was drunk?
Yeah, the entire night. She was slurring her words. Her eyes were bloodshot. She was so confused.
Did you take a video of how she was acting?
I did. We did take a video that night.
You have Exhibit 10 in front of you.
I do.
And is that the video?
Yes, it is.
Does it appear fair and accurate?
Yes.
Your Honor, we move Exhibit 10 into evidence.
Ms. Levin, any objection?
Yes, Your Honor, under 104B, conditional relevance. May I be heard?
Yes.
Your Honor, Ms. Marks's behavior in this video is only relevant to the extent at which Ms. Mehta or one of the other employees at the bar witnessed this behavior. And therefore, Ms. Marks's behaviors in isolation are not relevant unless opposing counsel can establish that Ms. Mehta was either in the vicinity while this video was recorded or watched the video herself on the night of the 24th.
May I respond to that, Your Honor?
Yes.
Two important things. First of all, the standard in today's trial is whether or not someone in Sonny Mehta's position knew or should have known that Jessica Marks was obviously intoxicated when she served her drinks. Second of all, Your Honor, this is going to show, this witness is going to testify that that is how Jessica Marks was acting on the night of March 24th, and is going to say that the whole night, that's how she was acting, which means that at some point when the defendant served her drinks, and we're going to link this on the cross of Sonny Mehta, at some point that night, the defendant did see that Jessica Marks looked that way.
May I respond to that, Your Honor?
All right. And then I'm going to allow Mr. Wright to respond, and then I will rule at that point.
Yes, Your Honor. Jury instruction 12 defines the standard for obvious intoxication. And as opposing counsel mentioned, the plaintiff has the burden to prove that a reasonable person in Sonny Mehta's position or in the position of one of the other bar employees would have recognized that Ms. Marks was obviously intoxicated from their interactions with her. And therefore, Your Honor, it is essential that opposing counsel establish that Ms. Mehta was in the vicinity while this video was recorded, or that she had an opportunity to watch this video on the night in question. Your Honor, Ms. Marks's behaviors on their own, without that foundation, are not relevant.
May I respond, Your Honor?
Yes.
Ms. Levin's going to testify that this video is an accurate representation of how Jessica Marks was acting that night. We're going to link that the defendant saw that she was acting that way and continued to serve her drinks. This is admissible testimony.
All right. As far as whether it's an accurate representation at any particular time of the evening, I think that's more an issue for cross-examination. At this point, I'm going to rule the video admissible and can be shown.
Of course, Your Honor. Mr. Wright, can we show that video? One moment, Your Honor, we're trying to get sound on that video.
You have to share the sound separately from the video. So you have to do 2 shares to get the video to play.
Yes, Your Honor. It appears Mr. Wright doesn't have the permission to share that sound. Your Honor, we'll show that Exhibit 10 now that it's already in evidence. We'll show that in closing arguments. But for now, Ms. Levin, that video, we're going to see. Is that how Jessica Marks was acting that night?
It's how she was acting the entire night we were at Sunny's bar. That's not the normal Jess I know or knew.
Did the defendant interact with Jessica any time after that video was made?
Yeah, she did.
Did the defendant say anything about how Jessica was acting?
She said, as we were leaving, turned to Jessica and pointed at, and she said that I hope this one's not driving. About Jessica.
You said that was before your last round. Did the defendant serve her drinks after seeing that she looked that way?
Yeah, the green tea shots. Sonny brought them to us.
Levin, I'm sorry I have to ask you this, but what happened after you left?
After we left, I called an Uber to come and pick us up so we could go back home, but Jessica, she went to her car and she grabbed her keys and she went in her car. And I was behind her in the Uber, and I saw her drive away, and I saw as her car went off the road into the ravine. And that was the last time I saw Jess.
Thank you, Ms. Levin. No further questions, Your Honor.
Ms. Levin, you wish to cross-examine?
Yes, Your Honor. Good afternoon, Ms. Levin. Can you see and hear me all right?
Yes, I can.
I just have to ask you a few more questions, okay?
Yeah.
Let's start by talking about a video that opposing counsel discussed with you on direct examination. When you took this video, you didn't see Sonny Mehta standing in the room, right?
No, Sonny came shortly after.
And you didn't show this video to Miss Mehta, right?
I didn't know I had to. It was obvious she was that bad the whole night.
You didn't show this video to any of the other employees at the bar?
No, I didn't know I had to.
Ms. Levin, I want to talk about the choices that Jessica Marks made hours before she set foot in Sonny's bar. You got to her Airbnb between 7 and 8 p.m. that night, true?
Yes, I did.
And when you got there, Miss Marks had 2 bottles of wine sitting out.
Yes, she did.
She posted a photograph of those 2 bottles of wine on Instagram, true?
She did, yeah.
Let the record reflect Miss Becker is displaying what's been pre-marked as Exhibit 5. Miss Levin, this is a truthful and accurate copy of what Miss Marks posted on Instagram, true?
Yeah, it is.
At this time, defense offers Exhibit 5 into evidence.
No objections, Your Honor.
All right, then it will be received into evidence.
Miss Levin, you saw Miss Marks have a glass or 2 of wine that evening, true?
Yeah, at her Airbnb.
So let me get this straight. Miss Marks chose to drink before she ever set foot in Sonny's bar.
She had 1 glass of wine, yeah.
And then Miss Marks drove the 2 of you to the bar that evening, didn't she?
We went to Sonny's rooftop bar, yeah.
And it was Miss Marks who drove you?
Yeah.
Miss Becker, we can take Exhibit 5 down now. Miss Levin, let's talk about whether Miss Marks was visibly intoxicated at the bar that night. On direct examination, you testified you thought she seemed drunk, right?
I did. It was obvious she was intoxicated from the way she was talking and walking. Yeah.
You were sitting upstairs on the patio that evening, right?
Yeah, we were.
There were about 10 or 12 other customers on that patio too?
I didn't really look, but I think it's around that, yeah.
You never heard any of those 10 or 12 customers go up to Miss Marks and tell her she should stop drinking, right?
No, they didn't. Why would they?
Well, Miss Levin, you never told Miss Marks she should stop drinking, did you?
No, Jess. No, she was stubborn and didn't listen to me.
Well, you never told her she should stop drinking, right?
Like I said, yeah.
You never took Miss Marks's keys.
No, it was a rental car. Jess would never let me take her keys.
Well, let's talk about the choices that Jessica Marks made at the bar that night. On direct examination, you gave us a list of all the drinks Miss Marks had that night. She ordered those drinks for herself, didn't she?
She did, and Sunny brought each one, yeah.
You'd never heard anyone else order for her?
No,
You never heard Miss Meta try to persuade Miss Marks to order more drinks?
no, she just kept bringing them.
Well, at the end of the night, when the two of you were standing in the parking lot, you offered Miss Marks a ride home in your Uber, didn't she? Didn't you?
I did. I offered her the Uber.
You offered it to her, but she refused, didn't she?
She did. She went in her car.
She said she was fine.
She was, but it was so clear that she wasn't.
Levin, you told us that Miss Marks got into her car. Before she did that, she said, "I've gotten pretty good at driving after a big night," right?
That's right, she said that.
So when given the choice between taking an Uber and driving herself, Miss Marks chose to drive.
She did. And that's the last time I saw her, yeah.
Thank you, Miss Levin. Thank you for your time. Nothing further.
Mr. Wright, will there be any redirect?
No redirect, Your Honor. May this witness be excused.
All right, the witness is excused. And at this point, then, plaintiff rests.
Yes, Your Honor. At this time, the plaintiff does rest.
All right. And then I guess we're actually to Ms. Levin. So at this point, I'll be referring to Counsel Levin then. Are you prepared to call defense first and only witness?
Yes, Your Honor. Defense calls Sunny Meta. May I proceed?
Anytime you're ready.
Good afternoon, Miss Meta.
Good afternoon.
Please introduce yourself to the court.
Hello, my name is Sunny Meta.
Why are you testifying today?
Well, I used to own Sunny's rooftop bar before I sold it, and I was working on the night Jessica Marks was there before she left the bar.
Do you know what happened to Miss Marks when she left your bar that evening?
I do. I found out later when the police came by that she'd crashed her car after leaving.
And what day did Miss Marks come into your bar?
March 24th, 2019.
Let's talk a little bit about March 24th. What time did Miss Marks get to the bar?
Around 9 p.m.
And did she come in with anyone else?
She did. She came in with one of her friends, Morgan Levin.
And did you serve the two of them that night?
I did. It was a Sunday, so it was a slower day. I was the only one waiting tables upstairs.
Let the record reflect Miss Becker is displaying what's already in evidence as Exhibit 17. Miss Meta, do you recognize this?
I do. That's the receipt that I gave Morgan Levin that night.
And looking at the drinks on this receipt, how many did Miss Marks order?
I would say 4 or 5 of those.
And how many hours was she at your bar for?
About 3.
All right, so maximum 5 drinks over the course of 3 hours. About how many drinks did you serve Miss Marks per hour?
Less than 2.
Ms. Becker, we can take Exhibit 17 down now. Ms. Mehta, let's talk about Ms. Marks's behavior that night. Did you hear Ms. Levin testify earlier that Jessica Marks tripped down the stairs on March 24th?
I did hear her say that, yes.
Well, did you see that happen?
No, I didn't. I never saw Jessica stumble, and certainly not near me.
Did you ever say, we might need to cut this one off?
No, I never said that. If we need to cut someone off, that's a serious discussion we have with the bartender working. It's not something we joke about, and it's certainly not something we bring up in front of the customer.
That's not what Ms. Levin told us happened. Let me ask, was Ms. Levin drinking that night?
She was, yeah.
Let's shift and talk about whether Ms. Marks was visibly intoxicated at the bar that evening. Do people drink at your bar?
They do. Most people come in and they'll order some appetizers and have a few drinks.
How can you tell when a customer has had too much to drink?
All bartenders were actually trained to look for signs of intoxication, to be able to draw the line between buzzed and intoxicated. There's signs. We look out for them. We watch for them in everyone.
What are some of the signs that you're trained to look for?
Well, first there's the physical signs. That would mostly be with the eyes. If they're bloodshot, watery, or sometimes even just a vacant gaze. That's why we make eye contact with the customers. The second one is slurred speech. That's why we try and speak with the customers to hear how they're sounding. And then there's others like lack of coordination, whether they be stumbling or if there's problems with hand-eye coordination.
Ms. Mehta, you told us earlier that you cut customers off if they've had too much to drink. Did you cut Ms. Marks off on the night of the 24th?
No, I didn't.
Why not?
Well, she wasn't displaying any of those signs I'd mentioned. When customers are displaying signs, that's when we draw the line and cut them off. But if they're not displaying signs, we don't have a reason to cut them off.
Do you know what happened when Ms. Marks left your bar that night?
I do. I spoke with the police later that night, and I found out that after she left the bar, she drove. And when she got on the PCH, or the Pacific Coast Highway, she crashed into a ravine. And when they were speaking with me, they told me it had killed her.
Ms. Mehta, when Ms. Marks left your bar that night, were you concerned about her safety?
No, I wasn't. I didn't see any signs that would be a point of concern.
Thank you, Ms. Mehta. No further questions at this time, Your Honor.
Mr. Wright, will there be any redirect?
Cross, Your Honor?
Yes, I'm sorry, right, recross.
Yes, Your Honor. Good afternoon.
Good afternoon.
You said that at no point that night did Miss Marks appear obviously intoxicated, right?
Yes, that's correct. There were no signs I could see.
Your Honor, this time my second chair is going to screen share constructively outside the presence of the jury, Exhibit 26, of which we would like to read portions of and admit into evidence. This exhibit is stipulated, authentic, and under the definition of 804A, it's an unavailable witness. It's stipulated by both parties. Mr. Wright, can we show exactly what portions we want to read? Now, Your Honor, we move those into evidence.
No objections to those portions of Stevie Redger's deposition, Your Honor.
All right. If there are no objections, then it will be received into evidence.
Mr. Wright, can we get that last portion up on the screen again? The question, did Sunny say anything to you about Jessica or her friend? Answered, Sunny didn't say anything to me about Jessica or her friend. Right after Sunny served them drinks, Jessica continued being loud. Sunny and I made eye contact, and Sunny did an eye roll. Mr. Wright, can we get the one before that? What makes you say Jessica wasn't perfectly sober? Answer, she was really loud and wasn't making a lot of sense. Ms. Mehta, I want to talk about your interactions with Jessica Marks that night. You never saw Jessica speaking loudly. Is that right?
I wouldn't say she was speaking abnormally loud, no. We have music playing, so most customers will be speaking louder so we can hear them, but not at a level that would trigger any sort of concern.
You didn't believe she was slurring her words, right?
Not when I spoke with her, no.
Mr. Wright, can we get Exhibit 10 on the screen?
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. You know, I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Ms. Mehta, she's loud in that video, isn't that right?
It sounded so through the video. I can't be sure how that equated in real life. I wasn't there at that time.
Well, you said you weren't there at that time. You were at her table 10 times throughout the night. True?
Yes, over the 3 hours she was there, I visited 8 or 10 times.
You'd agree in that video, looks like she's slurring her words, right?
She was definitely speaking slowly. It's hard to tell from the video if she was definitively slurring them, though.
You saw at the end, it looks like she's confused about which can to pick up, right?
It's possible. It did look like she switched to grab a different drink at the end.
In fact, at the end, she dropped that can. Isn't that true?
Yes, it looked like when she put it down, it dropped a little bit.
And so when you saw that video in your deposition hearing, you told the attorneys that she looked possibly drunk, right?
Yes, I told them it was a possibility.
Now, that night, you believe Jessica and Morgan ordered about the same number of drinks. True?
Around the same. They both ordered every time I went up there.
You learned from your deposition hearing that Jessica was 5 feet tall. True?
Yes, that's correct.
You learned that she was 19 years old. Isn't that right?
Yes, that's correct.
In fact, Miss Marks, she gave you that fake ID. You believe you checked it. True?
I
Your Honor, 403, more prejudicial than probative. May I explain?
All right.
Your Honor, both sides have stipulated, pursuant to pretrial order 14, that Jessica Marks was in fact a minor on the night of March 24th, 2019. We both agree Miss Marks was 19 years old. For opposing counsel to ask this witness questions about whether this witness checked Miss Marks's ID has very low probative value because pursuant to jury instruction 11, the plaintiff does not need to prove that Miss Mehta knew Miss Marks was a minor when she came into her bar on the 24th. Therefore, Your Honor, the prejudicial effect of this line of questioning far outweighs any probative value it might have.
May I
Mr.
respond?
Yes.
Your Honor, first of all, the bar for relevance is incredibly low, but let's talk about that 403 objection. This is going to show that the defendant saw the ID, and this line of questioning will establish that ID was clearly fake. She saw the ID. It didn't have height, gender, weight, and eye color. It was very clearly fake, but she saw the ID and continued to serve this minor drinks. This establishes that this witness, it can't be trusted when she tells us that Jessica wasn't appearing intoxicated because she let a minor into a bar that night. We can't trust this witness, and this is going to a credibility. Therefore, the relevance of this is pretty substantial. Under 403, it has to be, the prejudicial effect has to be substantially higher than the probative value, but the probative value itself is substantial. There isn't going to be a risk of endangering the jury to some undue prejudice. This is completely admissible testimony.
Let me have the question again.
Yes, Your Honor. I asked this witness, Ms. Mehta, that ID that Ms. Marks gave you was fake.
All right, so you're going to the ID as opposed to whether it's a stipulated fact that the decedent was underage, correct?
Yes, Your Honor.
All right, so this really doesn't go to the age as much as whether the ID is a fake. I'm going to overrule the objection, allow the question.
Yes,
Yeah.
Your Honor. No. Is that a yes to my question that that ID was fake?
The ID I was shown in my deposition, it was a fake.
Now, that ID, it was pretty clearly fake, wouldn't you say?
The one that they showed me in my deposition, yes, it was missing her height and that little hologram that Pennsylvania IDs have in the corner.
Right, those were two things that Jessica's ID didn't have, but it also didn't have a weight, right?
That's correct. The one they showed me didn't.
It also didn't have a gender, right?
That's correct.
Didn't have an eye color either, true?
No, it didn't.
During that deposition hearing, you also learned that Jessica Marks's BAC was 0.16, right?
I did. I found that out that time.
You're aware with your training that that's 16 times the legal limit for someone her age, true?
That's correct. For anyone under 21, that legal limit, it would be 0.01. So that's correct.
Thank you, Ms. Mehta. And no further questions, Your Honor.
Ms. Lemon, any cross?
Redirect examination, Your
Yes,
Honor?
redirect, I mean.
Of course, Your Honor. Ms. Mehta, on cross-examination, opposing counsel asked you a few questions about Exhibit 10, that video of Miss Marks in your bar. They talked to you about a deposition in which you said it was possible she was drunk in that video. Did you see Miss Marks exhibit those same behaviors in front of you?
No, when I saw her, she was acting not like that video.
How was she acting?
She seemed mostly okay. She wasn't slurring her words, her eyes weren't bloodshot, and she didn't seem to have any problems with coordination.
You told us that Miss Marks might have seemed tipsy that night. Is there a distinction between being tipsy and obviously intoxicated?
Yes, someone can be tipsy after one drink. It's not something that requires you stop serving. Tipsy is most people after a drink or two. Obviously intoxicated, it's when they're displaying signs. That's the point where someone would have to be cut off, not at tipsy or buzz.
Thank you, Ms. Mehta. No further questions at this time, Your Honor. And assuming no recross, may this witness please be excused?
Mr. Wright, will there be any recross?
No recross for this witness, Your Honor.
All right, then the witness is excused.
And with that, Your Honor, the defense rests.
All right, so before we go into closing arguments, if everyone would please switch back to speaker view. Also, since both witnesses have completed their testimony, this would be a good time to complete the witness portions of your ballot. So we'll take a moment to do that, and then we'll go into the closing arguments.
Yes, Your Honor.
All right, then at this time we'll proceed with the closing arguments for the plaintiff. Mr. Wright, are you prepared to start at this time?
Of course, Your Honor.
All right, anytime you're ready.
They saw, they served, and they didn't stop. It's as simple as that. Members of the jury, at one point that night, the defendant walked to Jessica's table with some drinks. Jessica was loud. She was slurring her words. She appeared exactly like she did in the video. Everyone saw that. But the defendant placed those drinks on her table, and the second she did that, Sonny's rooftop bar became liable for her death. Let me take you through the evidence you heard from today. Show you how you're not just relying on the witnesses that testified, and show you exactly how we've met our burden. See, members of the jury, today we had to prove to you three things. Defendants saw that Jessica Marks was clearly intoxicated. The defendant served her just a single drink more. And those drinks played a role in her death. Let's start with that first point. The defendant saw. Members of the jury, today you learned Jessica Marks was slurring her words. Eyes were bloodshot. Her vision was blurry. You learned that at one point in the middle of the night, Jessica fell down the stairs, right into the defendant. The defendant yelled out to her employees, "We need to cut this one off." She acknowledged it in front of the whole bar. And the whole bar watched. See, today you learned that an eyewitness saw Jessica was clearly drunk. And if you want to see it for yourself, take a look at the video.
Hi everyone, Morgan and I are in Hollywood. We're at a bar. Everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Members of the jury, even if you don't take Morgan's word for it, even if you don't take that video as evidence of her displaying signs of intoxication, learn that there was another person at the bar that night. A man named Stevie Redgers. Saw the whole thing. You learned, he said, Jessica was really loud. Wasn't making a lot of sense. But not only that, members of the jury, he gave you another specific instance where the defendant acknowledged just how drunk Jessica was. That's proof by a preponderance of the evidence. The defendant saw Jessica was clearly drunk and continued to serve her drinks. That brings us to the next point. The defendant served her again. And you learned the defendant served her drink after drink. Mr. Wright, can we get those drinks? Drink after drink after drink across 10 interactions, all throughout the night. You saw exactly what Jessica ordered. Can we get that receipt? That last round of drinks, it wasn't until the end of the night. After that video was recorded, after the defendant saw that Jessica was clearly intoxicated and acknowledged it to multiple people at the bar, the defendant served her. Those drinks caused her death. Members of the jury, there's no dispute in today's case. In fact, before we even started this trial, Jessica's autopsy was already in evidence. There's no dispute. Just 30 seconds after getting on the road that night, Jessica drove off the road, crashed into the bottom of a ravine where blood alcohol content was twice the legal limit for an adult, 16 times the legal limit for someone her age. The defendant didn't stop her. The defendant was required by law to stop her. Members of the jury, we've proven our case. That's why we ask that you hold them accountable and find them liable for Jessica's death. Because they saw, they served, they never stopped. Thank you.
All right, thank you, Mr. Wright. And Ms. Levin, are you ready to give the defense closing at this time?
Yes, Your Honor.
Anytime you are ready, you may proceed.
She controlled her choices. It's March 24th, 2019. There are two girls standing in the parking lot of Sonny's Rooftop Bar. Morgan Levin and Jessica Marks. We know now that only one of those girls made it home safely. The distinction between Miss Marks and Miss Levin, it wasn't how much they ate or how much they drank or who served them. It was the choice they made in the parking lot. Miss Marks chose to drive herself home. Morgan Levin took an Uber. Jessica Marks controlled her choices. Her choices cost her her life. Members of the jury, in a few moments, this case will be in your hands. You'll have to determine first whether the plaintiff met their burden, and if you find that they did, whether we met ours. Let's start with the plaintiff's case. Today, they had a burden to prove that Miss Marks was served alcohol while obviously intoxicated and that contributed to her death. They failed to meet that burden. Now, opposing counsel told you over and over again today that Miss Mehta saw, served, and didn't stop. Let's walk through each of those points one by one and take a closer look. Did Miss Mehta see Miss Marks' actions that night, see her exhibit any behaviors consistent with obvious intoxication? Well, the plaintiff showed you a video of Miss Marks in the bar that evening. You heard from the plaintiff's own witness, Miss Levin, that Miss Mehta didn't watch that video. Miss Mehta wasn't in the room while that video was recorded. She didn't see Miss Marks exhibit those behaviors. Now, you might be asking yourselves, well, why would Jessica Marks be acting any differently in the video than she would have been in front of Sonny Mehta? Think about how Jessica Marks felt that night. She was underage. She would have been fully aware she was drinking in that bar illegally. Members of the jury, she had every reason in the world to conceal her intoxication from the bar staff. Because if she'd really seemed that intoxicated the entire night, wouldn't someone else, another customer at the bar, the Uber driver, Miss Levin herself, wouldn't they have stopped her? Members of the jury, the fact of the matter is, Sonny Mehta didn't see how Miss Marks was acting that night. Did Miss Mehta overserve Miss Marks? Members of the jury, you heard today that Miss Mehta didn't actually serve Miss Marks that much alcohol. She served her 4 or 5 drinks over the course of 3 hours. Members of the jury, we know that Miss Marks's BAC at her time of death was 0.16. We agree to that. But again, we have to think about what Sonny Mehta was aware of. Sonny Mehta knew that she was serving one of her customers fewer than 2 drinks per hour. That's it. She didn't know Miss Marks's ultimate BAC all she knew is how much she was serving Miss Marks. The plaintiff told you that Sonny Mehta didn't save Miss Marks, didn't stop Miss Marks from driving home that night. Members of the jury, bar owners are not expected to stop their customers from driving home. They're not responsible for taking their customers' keys or ensuring that they get home safely. All that Miss Mehta had to do was ensure she didn't serve Miss Marks alcohol while she was obviously intoxicated. That's it. And we've shown that Miss Mehta did her job. She did not overserve Miss Marks. And if you find that the plaintiff has not met their burden, has not proven by a preponderance of the evidence that Jessica Marks was served alcohol while obviously intoxicated, that's it. Your assessment stops there, and Sonny's Rooftop Bar is not liable. But say you disagree. Say you think the plaintiff did meet their burden, then you have to consider our defense. Did Miss Mehta, did Miss Marks contribute, at least in part, to her own death? And members of the jury, that question, it's about Miss Marks's conscious choices. The plaintiff asked you to focus on just the 3 hours Miss Marks was in the bar that night. We're going to ask you to look at the full picture. Let's start here. Hours before Miss Marks even set foot in Sonny's bar, she chose to drink. That means she's partially responsible for that BAC of 0.16. You know, she drove herself to the bar that evening. When Miss Marks was standing in the parking lot, she already knew. She knew hours earlier she was planning to drive herself home. She made the choice to drive to the bar at 8 p.m. and at midnight, she followed through on that plan. Members of the jury, she said, "I've gotten pretty good at driving after a big night." Those are not the words of someone who was blackout drunk. Those are the words of someone in control. And no one is saying that Jessica Marks was a bad person. She was a teenager. She lost her life when she shouldn't have. But the devastation we feel when we think about the circumstances surrounding her death, it can't be reason to turn from the truth. Find Sonny's Rooftop Bar not liable. Thank you.
All right, thank you, Ms. Levin. Mr. Wright, will there be any rebuttal?
Yes, Your Honor. Members of the jury, I want to take a second to shift from the choices that they claim Jessica Marks made to the choices that these defense attorneys have made today. See, the defense, they chose to raise what's called an affirmative defense. They tried to pin the death of that 19-year-old girl on herself, on her negligence. That encapsulates this entire case. Witness after witness told you that the defendant noticed. Depositions told you the defendant acknowledged exactly how Jessica was acting. The defense knows that. The defense understands they gave her round after Jessica was clearly over her limit. But they've chosen to blame Jessica. They've chosen to deny all eyewitness testimony. They've chosen to deny her BAC. They've chosen to deny that she could hardly even walk to her car. They've chosen to deny that she fell down the stairs onto the defendant. They saw, they served, and they did not stop. Find them liable. Thank you.
All right, thank you, Mr. Wright.